Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. Court set to accept SEC Form D filing. A spokesperson denies backdating allegations. Before we move further, there is a new crypto airdrop now taking place on Telegram, which is about to launch anytime soon. Please make sure you participate in this airdrop. The link is in the description of the video. Don't miss out on this. Now let's continue with our video. The Securities and Exchange Commission, has confirmed that it intends to dispute a recent court decision by providing information regarding its appeal in the Ripple XRP lawsuit. They submitted Form C on October 16, but there is some dispute regarding the date of filing because the court stamp on the document indicates that it was on October 17. Due to this disparity, doubts have been raised regarding the file's date and its ethicalness. Here, Eleanor Tourette, a journalist for Fox Business, pointed out that many people are wondering whether or not the Securities and Exchange Commission missed the deadline for filing. On the other hand, she shed light on the fact that a spokeswoman for the SEC stated it was filed on time. A legal expert by the name of Meta Women noted that the fact that the filing has not yet been rejected indicates that it is highly possible that the court would adopt. Even though the SEC insists that it filed its paperwork on time, a great number of individuals have questioned whether or not the SEC missed the deadline for presenting its case regarding Ripple XRP. Mark Fagel, a former attorney who worked for the Securities and Exchange Commission, mentioned that the attachments to the document were compiled on Wednesday. The timing of when documents appear on the court docket can be uncertain. According to Fagel, who mentioned that it is normal for attorneys to work until the last minute before the deadline, he stated that this is the standard procedure for the legal process. If there is a method to alter this procedure, it would be greatly appreciated by a great number of attorneys. In conclusion, even though there is speculation regarding the date of the SEC submission, it is essential to acknowledge the standard procedures that are followed within the legal profession. The chief legal officer of Ripple, Stuart Alderdi, responded to the same and stated, "There are no surprises here. It has been made clear once again. The decision of the court that XRP is not a security is not being appealed by the parties involved. That decision is the law of the land." The legal system says, "There are still questions that have not been answered regarding the precise date that the documents were submitted and the time that they will be made available to the public. However, the SEC has suggested that they will be published shortly. In a recent filing, the Securities and Exchange Commission appealed a court order concerning Ripple's XRP sales. Specifically, the appeal focuses on three main points: the distribution of XRP to workers by Ripple, the sale of XRP through exchanges, and the transactions made by CEOs Brad Garlinghouse and Chris Larson. The chief legal officer of Ripple has now dropped hints about the possibility of a Form C filing the following week, which many people are keen to see. In an interview with the Good Morning Crypto show, James Murphy, also known as Metalawman, discussed the forthcoming filing that Ripple is about to make. He hopes that the appeal filed by Ripple will be more favorably received by the higher courts, where the judges will have the opportunity to probe more deeply into these complexities. James thinks that the relationship between XRP holders and Ripple is fundamentally distinct from the relationship between traditional investors and enterprises. This distinction has the potential to influence future choices in favor of Ripple. John James contends that the Securities and Exchange Commission's understanding of XRP is that security does not take into account the fact that holders of XRP do not immediately benefit from Ripple's operations or earnings. He thinks that previous judicial decisions regarding cases such as Telegram have incorrectly misunderstood the nature of these digital tokens, which has resulted in a misunderstanding regarding the definition of an investment contract. More information may be found at the following link: Ripple News, court to accept set Form C filing. The spokesperson denies backdating allegations, potential arguments by Ripple Store. He thinks that Ripple would argue that its sales to institutional investors and some transactions on the on-demand liquidity platform are not investment contracts. According to him, the Odyell argument is highly compelling. James explained that Ripple considers these sales to be wholesale contracts, implying that the objective was for institutions to resell XRP rather than directly invest in Ripple. In James's opinion, the fact that outdated legal frameworks are being applied to emerging technologies such as cryptocurrencies is extremely frustrating. By expressing hope that Ripple will be able to successfully fight the verdict of the court, he expressed the hope that the fines that were imposed may be removed. These penalties were computed based on the number of transactions that involved institutional sales and OWA, and they totaled $125 million. One of the most prominent figures in the cryptocurrency legal community, attorney Jeremy Hogan, has voiced his disapproval of the decision made by the United States Securities and Exchange Commission to appeal a portion of its recent loss against Ripple. Recently, the Securities and Exchange Commission submitted Form C for its appeal against Ripple. Hogan's criticism was direct, and he referred to the SEC's approach as a chicken choice. In his explanation, he explains that the SEC's appeal is solely directed at certain rulings, especially Ripple's programmatic sales of XRP on exchanges and its usage of the coin for payments. A victory that Ripple has already gained, the agency did not appeal the finding that XRP itself is not a security. This is an important factor to consider. Views of Hogan regarding the activities of the SEC. According to Hogan, the technique employed by the SEC presents an opportunity to increase one's wealth while accomplishing very little. It is the fact that the Securities and Exchange Commission could have presented its case against Ripple's leaders, Brad Garlinghouse and Chris Larsen, in front of a jury rather than attempting to resuscitate those charges at this time that is the source of his irritation. In the beginning, the Securities and Exchange Commission filed a lawsuit against Garlinghouse and Larsen for aiding and abetting unregistered securities transactions. However, in late 2023, the SEC dismissed all charges against the executives, which was yet another significant success for Ripple. A full trial in front of the public, which Hogan referred to as a chicken move, was avoided by bringing back the charges, which he compared to a retreat. Hogan suggested that this was done to avoid the situation. Furthermore, Hogan explained de novo, highlighting the fact that the appeal court will examine the legal concerns without deferring to the decision made by the lower court before it. This indicates that the Securities and Exchange Commission is disputing the interpretation of statutes rather than the findings of factual investigations. This appeal by the SEC has wider reaching repercussions, and Hogan has warned that it may have unintended consequences. A victory for the Securities and Exchange Commission could result in financial fines for Ripple. However, Hogan contended that this would not protect investors, which is the fundamental goal of the SEC. A cross appeal by Ripple might also limit the jurisdiction of the Securities and Exchange Commission seat that imposed the security label on cryptocurrencies. In addition to Hogan, Brad Garlinghouse, the CEO of Ripple, expressed his dissatisfaction by noting that the actions of the SEC are causing more adverse effects than positive ones. Garlinghouse believes that the information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.